Hey everybody, it's Hussein Kabani, your favorite broker, and I'm here with Gathya, with Nava Wilson Law.
Hi.
You guys probably know her if you've been watching my channel. And Gathya, I have you here today because my phone has been buzzing with people that have bought pre-construction condos and they can't close them.
So not good calls, unfortunately.
Not good calls. And unfortunately, even on top of that, I can't really do anything.
Yeah.
You know what I mean? Like, I think they're in a position where they're kind of stuck at this point. And I don't want to kind of like keep answering these questions. So I don't mind taking the calls, but like, it just becomes repetitive, right?
For sure, yeah.
And sometimes I think people are even like kind of shy or standoffish to even call and ask the questions. So I decided to have you over, and thanks for coming by.
Of course.
And so we just put together this little video. So if somebody is kind of in a situation, this kind of gives them some pointers about what they can actually do.
That makes sense.
Cool. So basically, I just want to start off with like, what does default actually mean in Ontario?
Sure. So you will obviously either side can default. A buyer or a seller can default in an agreement of purchase and sale. 99% is the buyer. So we'll sort of focus on that.
Yeah.
So as a buyer, you have one responsibility, and that's to bring funds to complete the purchase of the home. So when you're unable to do that, which is really your only obligation, albeit a big obligation, you are in breach of the agreement, which means that you cannot fulfill your obligation and this transaction is not going to be completed. So again, it can happen in either context, in a new build context or in a resale home. It's more prevalent with new builds because you signed an agreement of purchase and sale like 3 years ago, 4 years ago when the market was the way it was. And now all these new builds are coming for closing. So you usually, it takes 3-4 years. So if you're signing agreements from like 2022, and now that property is coming to close and you're getting an appraisal and your appraised value is 200, 300,000 less than what you were supposed to purchase for. So when you did that mental math in your head, you said, okay, I'm going to get a mortgage for 80% of my purchase price. And, I have the rest of that money ready, that the other 20% I have, and we're good. But then now you're getting 80%, not of your purchase price, but you're getting 80% of the value that it's appraised for. So let's take the example. You have $1 million home. In your head, you thought you were getting an $800,000 mortgage, but really it was appraised for, say, $800,000. So now your mortgage is closer to $650-ish. So that gap, that delta of that $150 between what you thought you were getting and what you need to get, and what you actually got, is now coming out of your pocket. Yeah. And I don't know how many people have $150,000 in their pocket. Yeah, ready. So then you're in these situations where you're not able to close. So especially with, like I said, with new builds, these closings are finally rolling around, and the market being the way that it is, everyone's appraisals are coming low. Yeah. So that's essentially how the default sort of happens.
Right. And I guess just a side note, like there is some lenders, I know like RBC with certain projects, they're kind of giving a blanket appraisal of saying like, okay, you purchase it for $1 million. We know it's like 650 or 800, whatever the number is, but we're still going to say it's $1 million. But the problem I still think is qualifying for it, right? So even if they give you a blanket appraisal on the property, you still got to qualify for this mortgage.
For sure. Yeah. And that's the problem. You have these firm agreement of purchase and sales because most of the time they are firm. And, you're like most people, it's like, we'll sort it out, we'll figure it out. And like you said, a lot of builders are working with lenders right now. So they have, like this RBC thing, stuff like that. But now, like you mentioned, you have to qualify. So you need to have the proper income, this and that. And obviously banks are getting more stringent. So it's not easy to qualify. Like you can on paper be an amazing candidate and still have a difficult time qualifying. So that always becomes an issue. So then either you're going to private, but obviously with private, the cost of borrowing goes up. So it's like every which way you're almost losing. Yeah. So it is a really difficult situation to be in. I'm very sympathetic to buyers that reach out and are unable to close. But the problem is, and I feel like a lot of buyers have a hard time sort of swallowing this. And every time I have to have this conversation, it's difficult, is them understanding that they're still responsible. Yeah. So I'll have buyers call me and say, appraisal came in low, I can't close, like what happens next? And I'll explain the process to them, and their answer is, yeah, but the appraisal, and I'm like, yeah, I get that, you get that, the builder gets that, the judge even gets that, and they're sympathetic.
Yeah.
But at the end of the day, this is a contract, and you are breaching a contract. Like, that's how the court is going to look at it, unfortunately. So it is a very difficult thing to swallow, because you're like, hey, I'm losing money, I'm not even getting the house, and on top of that, I'm getting sued. So it is a really difficult position to be in, unfortunately.
Sometimes when I get calls from these buyers, they're just like, they understand like a lot of this is going on, and obviously they're still devastated about this whole thing, because it's pretty much all their savings that they put into this, thinking that this is going to go on forever. However, they hedge their bets, but then they're like, okay, well, I guess the worst case is I'm just going to lose my deposit. That's common. Like, that's that's a common thing I get. Like, I don't think that's true.
So it really will depend again on the losses. So the starting point is, unless your deposit is like 50% of your purchase price, which is never really happening, the starting point is your deposit is gone.
And is that like automatic? Like, once you're in breach, like, and you fail to close, is that deposit just gone?
So it's gone in the sense that as soon as you breach, the seller has earned that deposit. They have the right to that deposit. If it's a new build, depending on if you've paid it to a trust account or if you paid it to the builder directly. If you paid it to the builder directly, it's gone. It's probably already spent.
Okay.
So you're not getting that money back. Where in normal transaction, in a resale transaction, where you pay it to the brokerage, because it's being held in a trust account, the physical money will still remain on that trust account until the court orders that it be released. But like the seller has earned that deposit as soon as the breach has happened. So starting point is your deposit's gone, like I said, especially if it's a builder that you've paid directly your deposit. Like I said, they've likely already spent it. But that is the starting point. So let's use the example again, $1 million. Okay. You're unable to close. Even if the builder resells that property for $1 million, your deposit's gone. So the starting point is your deposit's gone. If they lose even more than your deposit, then they can come after you for the difference.
Right.
So the minimum they're getting is the deposit, and then the ceiling is whatever that loss is. So if they sell, your deposit's $100,000, but they sell for $200,000 less, they're going to come after you for that 100 plus their carrying costs, etc. So a lot of people, I agree with you that there is a misconception that the deposit is sort of the end all, but it unfortunately is not. Depending on sort of how severe the drop is.
Yeah. So like the next thing I automatically get from that is that, okay, so I'm going to lose my deposit. If there's a loss on what they sell the property for, they're going to come after me for that. Like, how does that work? Like, how will they come after them for it? Like, what kind of ways does this builder have to kind of get the balance of the money off of them?
That's a great question. So normally, normal builders, what they'll do is sort of as soon as you breach, in fairness, they will try to work with you. They're not the kindest in the sense of like they're going to give, like, it's not like they're automatically going to drop the price or something, but they will try to work with you. So I've seen, especially recently, because there's so many people having this issue, builders are doing vendor take back mortgages. Builders are doing suite swaps. So if you've bought, say, 1,000 square foot unit, they're letting you, get a smaller unit, and your deposit is carried over. Cool. Yeah, they usually charge a fee to swap it, but it's still like the math. The options there. They're doing extensions, they're willing to grant extensions, things like that. So builders are definitely trying to work with buyers. Because
they want to get it closed too.
Of course, they're here to make money, and the way they make money is by closing units. So that's usually the starting point. The builder will reach out and say, listen, like, these are the options available for you. Close. Try your best to essentially, like, in not a nice way, they're basically saying try your best to close. If you're still unable to close and you've exercised your options, and sometimes the numbers just don't make sense. Like, we've had clients come and they're willing to close with a private, and we run the numbers, and it honestly, like, it's almost cheaper to breach, because when you include all the fees, it's not whatever. So you really have to run numbers for this to make sense. If it doesn't make sense and you still are unable to close, the builder will have to sue you. So you will get what we call called a statement of claim, which is essentially the first step in the process. And they will sue you for the difference of what they lost. And they get what we call a judgment. So the judgment is their sort of ticket to collect from you. So if you have other properties, they can come after your other properties. If you work, they can garnish your wages. If you hold money in the bank, they can come after that money. It is a process, but those are sort of the main avenues of collection for the bank. Again, I'm sorry, for the builder. Again, they will always, most builders will always try to still, try to negotiate with you, reach a settlement. Because same thing, they just want the money. They're not here to, make your life difficult. It's just the reality of the situation. But that's essentially how they would collect their money from you.
So if they go this route, like let's just say like someone has defaulted, like they can't come up with it. Eventually this unit does sell. How long do they have? Like someone could probably think, oh, okay, well I breached and I lost my deposit and nothing's happening. And they think like, okay, everything's behind them now. How long could this take?
So the limitation period in Ontario is 2 years.
Okay.
So it is 2 years from the date of loss. So that doesn't always mean the date of breach, because they won't know their loss until they resell.
So they have 2 years after they've resold the unit.
So once they've crystallized their loss, they have 2 years from that. Wow. In fairness, a lot of builders move quick though, because they're scared that you're gonna disappear.
Of course.
So usually, like within weeks of breaching, they'll at least start the process.
Right.
They might start the process, then do absolutely nothing after that. I have files like that where the clients got sued immediately after breach, and now it's been like 9 months, and I haven't heard from the lawyer. I also have no, we're just sort of waiting. So most builders will start right away, but
they have to crystallize the loss at that point too, though. Like they have to have the loss and then they can
So sometimes even before it's resold, they'll do based on like market value. So they'll say, a market value is 200,000 less, so they'll sue for that. It doesn't have to be sold by the time they start the claim, but usually it's sold by the time they get the judgment.
Okay. Yeah, at least that way they can get the right amount of whatever's going to be owed to them. And then if they do go to that point of like judgment, like how long does it take them? Like if they start to garnish your wages, is there also something I've heard, like if you make less than X, then they can't really garnish your wages? But I think that is a lower threshold as well.
So there's things around the types of income that they can garnish. So like they can't garnish like your ODSP, things like that. It's a percentage, so it's not a fixed amount. So they can, I think it's 20% of your wages that they can garnish.
That they can take.
And again, like if you're self-employed, that makes it a little bit more difficult, things like that. But they can take your wages if you're just like a normal salaried employee, and they garnish your employer directly, so that it's not like it's flowing through you, it flows through your employer.
I'll throw this out there because it was a weird situation someone called me about, and you don't have to comment if you don't want to, okay? But like basically this guy calls me and he tells me like, okay, we have this condo coming up for closing in downtown. It's actually in my son's name and we've paid the deposit in my son's name. He owns nothing. So he's like, I'm thinking that we're just going to let it go to breach and let him come after him. Like, we're going to lose the deposit. He's got nothing. Like, what are they going to come after at that point? I didn't really comment further on that, but like.
So unless that person, that child intends to never buy property.
Okay.
That would not be a good idea, only because the only way that you can ever get rid of a judgment in the sense of like you legally do not have to pay it back is if you file for bankruptcy.
Okay.
So if you choose to file for bankruptcy, then they get extinguished. Your judgments get extinguished. So then you don't have to legally pay it back. But if not, like say the builder does get judgment against their son, like he's going to have difficulty getting a loan in the future. He's going to have difficulty buying a property. So there is definitely like it impacts you. And I always, it's actually interesting that was their option, because most young people, they don't like to get judgments against them because of the fact that, they're just starting out. They don't want to ruin their credit, etc. So even though he doesn't own anything now, unless it's going to stay that way, it's not something that sort of is a good idea, unfortunately.
Because I guess if they have a judgment, I guess like if they're applying for mortgages and things like that, that's going to come up at the same time.
Yeah. So, like even if they go to get a mortgage, if they go to buy another property, anything, this will pop up. Because most like financial institutions, they do what we call a writ search. Yeah. And this will come up to show that there is a judgment, and I assume it's going to be a fairly large judgment. So it is going to cause difficulty in the future, again, unless he's going to file for bankruptcy.
Okay. All right. I mean, we kind of touched on what like a builder can help you out with. Like they might look at maybe reducing the price. So if it helps you out by them closing and it works for them, they might try to offer you like a private or like a vendor take back on some of it. Might do a suite swap. I didn't know about that. That's pretty cool. So like there are things that they're willing to do.
Yeah, for sure. I do find like I feel like we've talked about this probably years ago, and we're in the second wave of breaches, let's call it. I do find that this round, builders are definitely getting a little bit more creative with their solutions. So they are like willing to work with their buyers. Again, they're here to make money, and they only make money when deals close. So they're definitely common ones I've seen are the VTB. They're not usually big on price reductions. I will be honest.
Yeah.
I'm sure they also, when they were running their numbers, they were basing off on these numbers, and that might be part of the reason. But they're not big on price reductions. But they are definitely helping around with vendor take back mortgages, extensions. Like I have deals like they were supposed to close in like October, and they've just been extending, and the builder's okay. Like yes, they'll charge a fee, etc., but they're willing to extend. So I would definitely, like, my suggestion, and we sort of talked about this before, is like this problem is not going to go away.
Yeah.
So I would definitely, like, my suggestion is try to actively find a solution.
Yeah.
So reach out to your lawyer, reach out to the sales office. We always tell clients, especially with builders, reach out to the sales office directly. They are here to make deals happen. So they're usually a little bit more lenient. They're a little bit more friendly versus reaching out to, like, having a conversation with their lawyer. So we always tell our clients, like, if you're asking for something from your builder, you do this simultaneously. I'll talk to the lawyer, but at the same time, you reach out directly to the sales office. Be like, listen, this is a situation. Appraisal's low, whatever the case is. What can you do for me?
Yeah.
And usually they're willing to help in some capacity.
Right.
So I would definitely suggest, like, take active steps. This is not going away. Builder's not going to forgive you. They're not going to be like, hey, no problem.
Yeah.
Like,
We'll just sell it to someone else.
Yeah. So they are going to come after you one way or the other. So my suggestion would be proactive.
Yeah. And I mean, we know that there's a lot of people in this boat right now. I did a short clip on Instagram, and I got like 7 calls, right after doing that little clip. But obviously, there's a lot of people that won't even reach out. But if somebody is in this situation right now where they're looking at it and they know that they got to close in 6 months or a year, but they already know that it's impossible, like, how should they approach this? What should they start doing right now? And when is it time to involve a lawyer if they know that this is not, like, they don't have the ability to close this?
So I would always, maybe I'm biased because I am a lawyer, I would always suggest getting your lawyer involved as soon as possible, especially if you know that it's going off the rails, for 2 reasons. One, you want someone to be advising you properly. So if the builder does give you options, understanding what those options are, the risk to you, the reward to you, all of that. But I would say as soon as possible, get people involved. So whether, even getting your mortgage qualification, like, I would say do that as soon as possible. Get your lawyer involved. If you need a creative solution in the sense of a VTB or something like that, there's no harm in having those conversations early, but there is definitely harm in having them too late.
Right.
And like I said, reach out to the sales office yourself, see what they can do for you. Because it's not going to go away.
Yeah. So I guess the best thing, just to recap it, would be is, like, if you know that you're going to have a problem, that right now you don't see a solution for being able to close this thing for whatever the reason is, go to a lawyer, get a lawyer, retain a lawyer, pay your retainer, and start to get legal advice, right? And then approach the sales office, because I feel like me personally, that's what I would want to do, right? Because, like, even what the sales office would tell me or how I should approach the sales office, I would want someone to kind of coach me on how to do that.
For sure.
Someone that's been seeing these kind of deals come through their desk, right? So basically, I would want to retain a lawyer, make sure I have retained them by paying the retainer, and then getting that advice to go to the sales office. Whatever they're sending me, I want to send it back to the lawyer, and then let, like, the lawyer that I have chosen to work with the builder's lawyer at the same time.
That's like, I have a client right now, and we're doing the suite swap for him. And that's essentially how it was. It was like he came to me and was like, "Hey, this is the situation. Appraisal's gone low. Like, what are my options?" So I reached out to the lawyer. At the same time, I told him, I'm like, reach out to the sales office, see what they're saying, and they offered the suite swap. So now we're sort of that's what I mean by simultaneous, because he's negotiated the fact that we're having a suite swap, but I'm making sure things like the deposit is getting carried over, and where closing is being extended properly, and there's no fees associated with that, things like that. So it really is like a two-man approach in this. So it works to have everyone involved at the same time.
Yeah. So I guess this all boils down to, it's like a really crappy scenario that someone could be in right now. But the worst thing that you could do is just ignore it and hope that it's going to go away.
Yes.
You should get legal representation and then start to work with everyone that you possibly can. Let your lawyer do what they're going to do. Work with the sales office. Continue to work with whoever's helping you with the mortgage. Hopefully it's Varen. But like, just keep everything going all at once, right? Because I'm sure the builder won't care at the end of the day if you're still in a breach, but at least you've tried everything that you can do. And maybe they will recognize that, hey, like this person approached me 6 months, a year ago and started to say, hey, like I have a problem. Because the other thing I was going to add is that sometimes people are calling me and they're like, okay, Hussein, let's just assign it. It's like a light bulb idea went off in their head. I'm like, dude, you know how the assignment market looks right now?
Yeah.
It's not good.
Especially with condos right now, even with assignments, it's very difficult. So it is that, but that is again a difficult option, but it still also is an option available. So that's what I'm saying. Like, I don't think it has to be like as soon as you decide or you have come to the realization that you cannot afford the house, like it's over. There are other options available for you. So I would definitely explore those options before you make that decision. And I tell clients this all the time. Understand that a breach is the clearest form of legal obligation. Like if you breach, like you are getting if we're in front of a judge, you are going to get a judgment against you.
It's you're guilty essentially.
Like barring some extraordinary circumstances, you are going to get a judgment against you. So this is not something that is a decision you can make lightly, because knowing that fact, because clients will always come to me, they're like, oh, what should I do? I'm like, you need to look at the numbers, see what makes sense, write things down. But again, just be proactive.
And now that you have said it, and if someone's made it this far, the next question they're going to call me and said, what does that mean? Extraordinary circumstance. Like, I was in the hospital for a slip and fall. Like, see, that's bad news. Like, so what does this mean? Like, what can someone, like, what can they say?
To be honest, when I say extraordinary, I mean, like, I can't even, like, a slip, like, I can tell you what's not extraordinary, a slip and fall.
Yeah.
I've had a deal. It was on assignment. So my client was assigning to a purchaser. The purchaser died.
Oh.
Literally like 2 weeks before closing, the purchaser died, and it was still a breach.
Wow.
So that's what I'm saying. I can't even tell you an extraordinary circumstance where the judge will say, no, this is not a breach.
Yeah.
No problem. You're not responsible for this money.
Yeah.
So it literally nothing. I can't even think.
I guess
of
the only
something.
thing is, if unfortunately if you pass away in this whole process, like they can't really come after you at that point.
Well, they come after your estate. But
You know what? There's one example that I can come up to, but it didn't actually go to like a court or whatever else.
Okay.
The builder just found some sympathy. Like I talked to this couple before they purchased the pre-con. It was a house, and unfortunately, the husband passed away on vacation, and she couldn't do anything about it. So they did actually let her out of the deal.
Oh, wow.
Yeah, they actually let her out of the deal, but I guess that would be like very extreme.
Yeah.
And the
But
builder
even
actually
then,
saw some sympathy in
that's
that.
the thing. That's sympathy. That's not legal.
Yeah.
Obligation being abolished.
Yeah.
That is a sympathetic.
So if the builder didn't want to do that, they'd be
Yeah.
like, "Hey, I'm sorry that happened, but like,
too bad,
you
yeah.
gotta still close this deal."
Essentially, yeah, because that's what happened. They, the assignee passed away, and they sued her estate. They sued my client because they were like, "Oh, you were the
You're still
original
responsible.
purchaser." Yeah. Even though she passed away, like it was literally like 2 weeks before the closing. So yeah, from the legal obligation doesn't go away. It just hopefully you're working with nice people that will give you a break.
And now this might be slightly off topic, but since we brought it up, like if you assign a contract, you're still responsible for that contract to close?
Yes, you are responsible for all the obligations under the agreement until it is closed. Only once it is closed, you are
And funds are transferred and received,
you
then that's the
can
only way
walk
you're off
away.
the hook.
Yeah. So even an assignment, like you mentioned, a lot of people have this light bulb idea where they're like, hey, let's assign. But if your assignee can't close, then you are also still liable. Obviously, you can try to go after your assignee, but the problem with all this is like, if they could have closed, they would have. Like, no one is out here being like, I just don't feel like closing. Like, let's not close.
I heard of some people. They're just like, hey, the condo value came down like 400 grand. Like,
fair enough. Yeah.
I'm not closing it. I mean, they're still going to be responsible for all of this.
But the problem, like, because they are going to be responsible, a lot of people will do all they can before it gets to that point.
But you know what? This also reminds me. Someone's like, hey, I'm actually going to transfer all of my stuff out of my name. Like, how would that work? Like, can someone actually go through and say, okay, I own X, Y, and Z, and I'm going to get it out of my name before they come after me?
So I love that question because it's another light bulb moment. People thought they were the smartest person in the world when they thought of that. But the answer is yes. You can transfer your assets. You can choose to do that. Just like you can choose to transfer it, the seller, let's call them the builder in the scenario, can bring proceedings to essentially reverse that transaction. So it's called a fraudulent conveyance. That's the legal sort of terminology for it. And it's transferring your assets for the purposes of avoiding your debts is really the point. So it's a side and separate legal proceeding than the actual breach. Breach, like I said, is very clear moving. Like there's no sort of difficulty in getting that judgment. But this the builder will have to work for. They will have to prove that you did in fact. In the middle of litigation is when you all like magically just transfer all your assets. You transfer them to your wife or your husband or your brother or your sister. And you have these like this $1 million home that you transferred for $2 and things like that. So the court will look at factors like that, and they can choose to say, this was a fraudulent conveyance. We're going to essentially reverse it. But it's a separate proceeding. Not all creditors will take that extra step and do that, but it's available to them. So it's a risk essentially that you're taking. You may be able to transfer everything, and they're like, "Hey, it's not worth the time. It's not worth the effort, and leave you alone."
Could I would obviously say look for legal advice, but like it could add a layer of protection for somebody.
And it also is like the timeline. Like if you're doing it, like you got served with the statement of claim and then tomorrow you're transferring, like obviously the court is going to look at that and say, listen, like I know why you did that. So it's a risk that you take, but people do definitely, exercise that.
Yeah. Anything else that you could think of in this?
I would just say, like I said, be proactive, get good advice, get good advisors, get a second opinion. And it is what it is. Like if you have to breach, you breach, and you unfortunately have to deal with the consequences. I'm hopefully the market for everyone turns around, and all these properties can gain some value, because it's a shitty situation to be in. It's shitty for the buyer. It's shitty for the seller too. Yep. No one wants to be there. So it's just the unfortunate reality of the real estate market. You never know. Like we were talking about, like all property up and down, you never know when that's going to happen. And when you have these agreements that you're signing years in advance, you just never know.
You don't know. But I guess at the same time, you got to like approach it with caution too, right? Like the thing is that like sometimes I'm getting calls from someone that says I signed 3. And it's just like, did you really have to sign 3 of these agreements all at the same time? But the builder was saying we only have to put 10 points down, and it was going to continue to go up, and it's going to be worth X at that time. So,
but it's like, have you seen Madame's doing the
price freeze or price protection?
Yeah.
But dude, here's the thing. Like I like Madame as a builder. Okay, I bought a bunch of their homes before and whatever. But the thing is that it's so gimmicky. It's so gimmicky in the sense of like, I already know that you're not putting a shovel in the ground unless you get this number. And the other thing is that if we could all be very honest here right now, what are they going to do? They're going to, like, I'm not saying Madame is going to do this, but like another builder, if they really want to do it, they have like a network of agents. What they're going to do is, this is the public price, and this is my special agent's price. You know what I mean? I mean, it's happening in the market right now. So they're never really going to get booked on it.
But it's a gimmick. Agree. Yeah, I do agree it's gimmicky because everyone's so scared. Like no one is entering into new agreement purchase and sale. And what I'm finding now is a lot of people people that are,
Yeah.
they're conditional. I didn't see a conditional builder agreement until last year. So you have all like the buyers definitely have a little bit more power, negotiation power right now. So I have these buyers that are coming to me with these conditional offers that we're reviewing and all of that, because people are so scared. You hear, and rightfully so, but you hear all these stories about people who couldn't close and getting sued and this and that, and so I think that Mattamy is trying to get rid of that, which I don't.
But it's a little bit false. It's a little bit misleading, I would say, at the same time, because I've already talked to somebody about this, and they're like, like when the market drops, I was like, no. If you bought a house for $1.2 million off of them, and the market value for the neighbor just sold for like 1.1 million, they're not giving you 100,000.
Yeah.
That means that if Mattamy sold you that house, or a builder sold you that for 1.2, and they dropped the price to 1.1, then they're going to give you a credit of 100, not because the market did it.
No, I agree with you. Yeah. So there's definitely get more information before you sign that agreement.
Yeah. Or have a conditional period and get your lawyer to review it, right?
But I do I think that Mattamy is definitely trying to get rid of that fear that a lot of buyers do have.
And I'm honestly biased. I really like Mattamy Builds, and I bought a bunch of properties off of them, and I know that they try to do whatever they can and whatever. So I am a huge fan of Mattamy Builds, but I think it's a little gimmicky.
Fair enough. Yeah. But in fairness, it's working, because so many people sent me that post being like, "Hey, like, did you see what Mattamy is doing?"
So it's working.
It's definitely working. I would like to see. Well, hopefully they don't have to use it, but I would like to see how the execution.
I just don't think they'll put a shovel in the ground. Like, if they have to sell below that number, they won't put a shovel in the ground. And I'm not saying they will do it, but like I said, like, I already know other builders that are going and having a special price list for people, like, here's an NDA you got to sign, like, you're
damn.
It's happening out there. So it's like it's not all transparent, right? So they are making you sign a disclosure. You're not going to disclose this price list to anybody, but here's a price list. Mattamy's not doing that as far as I know, but there are other builders out there doing it.
Oh yeah, there's definitely a lot of there's a lot of small builders right now that are canceling projects as well. That's my other takeaway for anyone that is already entered into an agreement of purchase and sale with the builder: do not sign amendments without getting them reviewed.
There you go.
I have so many people that have come to me being like, "Hey, my property was supposed to close on this date. It didn't close. It got extended. It's been like 5 years. And what can I do? Can I walk away?" And they've willingly signed an amendment that changes the closing date. And if both parties agree, there's no compensation, things like that. So if you have entered into an agreement purchase and sale already, no problem. But before you sign any amendment that the builder sends you, and they send it to you like, "Hey, like, I just need a little signature here." No, before you sign it, get it reviewed by a lawyer.
Because there is a clause in there in that tearing on paperwork that says if we
of
don't
critical
deliver
dates.
by X, like, you can walk away. It's a far X. But like, you can kind of walk away from this whole thing.
So there's a purchaser termination date, which is basically, if the property is not closed by this date, you can walk away. Free and clear, no problem. You get your deposit back, everything, no problem. But like I said, what you have is these sales offices sending these, they're just like a DocuSign document that's just like, "Hey, slight amendment, can you sign this?" And now you're pushing those dates out. So say your termination date was actually, tomorrow, they're pushing it out 5 years from now. And now you're stuck in this contract, your money is stuck, you're stuck, you have no home. So definitely, big takeaway is get any amendments reviewed by a lawyer. I've had builders send amendments to increase the purchase price. Yeah.
Really?
There was a project, it wasn't in the GTA, it was out east somewhere. And the builder, like I said, like, it was like almost like, we just like slight change. They were sending out amendments to increase the purchase price by $200,000.
No way, that's not.
And thankfully, like, a couple of people did come to see me, and I was like, "You absolutely don't need to sign this if you don't want to." Obviously, the risk is that they cancel the project. Don't get me wrong, but you don't have to sign this if you don't want to. But that is 2 out of like, how many people sign that without getting it reviewed? So definitely get your amendments reviewed, because even now, like, I have clients that are trying to walk away from deals, not because of the market or anything. It's just, it's been so long. Especially with the smaller builders, I find that, which, it has its own difficulties being a small builder. But, it's like they were signing, I think he signed the agreement purchase in like 2021.
Wow.
And like, they haven't even put a shovel in the ground. And he's like, "Hey, like, what can I do? And I reviewed his documents, and lo and behold, he signed an amendment that pushed out all the dates. So now, instead of having the power to be like, hey, we're walking away, like that's it, we're now like back in this negotiation with the builder because we're legally bound by the contract. So it's just not a good place to be.
I just think that also, because you mentioned this, like I find that people take this very lightly. Like I honestly think that people take it lightly of signing contracts in real estate. Like, and honestly, it scares me sometimes because we do electronic signatures a lot now too. And I send out an agreement to somebody, and like 2 seconds later it's signed. I'm like, dude, like you should read this thing. You know what I mean? Like we've gone over it before we sent it as well, but like you should actually read through this stuff.
Sure.
And any of my purchases, like even in my resale business, any of my purchases, I have 3 main clauses: financing, home inspection, given. I have a lawyer review clause in every single thing.
Good.
You know what the crappy part of, I'm going to vent here. The crappy part about this lawyer review clause is most of these resale agents don't understand what it actually even means, a lawyer review clause. They're like, why do you need to review this contract? You wrote it, right? Like it's good, right? I was like, yeah, I get that. But then they're okay for the same 5 days accepting a home inspection and a financing. And if I want to be a prick, like honestly, I'm walking away and saying like, I don't like the scratch on the kitchen cabinet. Like I'm legit walking away from that. So why would you cross that out and ruin my buyer's confidence at the same time? Why wouldn't you want to protect yourself? Like at this point, it looks like you crossed out this clause, and I'm going to make it look like you crossed it out because you did. Do you know what I mean? Because if they're like, I don't like this clause, I was like, if you really don't like it, it doesn't mean anything. You're accepting the other two. Like you cross it out if you really don't like it, and I'll try to explain it to my buyer. But it's like, why wouldn't you want this layer of protection for yourself? Like your seller, your buyers, you as an agent, like.
And it's crazy because like this is going to be is the, if not one of the biggest investments you are making in your entire life. So it is always so crazy because I have clients like that too, where they'll come to me after the condition is waived. And I'm like, then what was the point? Like, why are you
I can't
like,
help you now.
So then it's like, now I'm like, do you still want me to review? Because if I find issues, like what's the point? Because we're bound by this contract. So yeah, definitely get your stuff reviewed.
Like I think it's important to have this clause in there. And the other thing also I find is that people that would sign you build construct, like, it's from a builder, the agreement's fine. But I don't know, I've had every contract reviewed by a lawyer when I've purchased new construction, and it's like they always find something in there. It's always in there. It's written one way for the builder.
1000%.
It's like, first time I ever like had a condo purchase, they went through and they were like, no, we're going to cap this, cap this, cap this, cap this. I was like, I didn't even know that was an option to do.
In builder agreements are the most one-sided document you will ever read in your entire life. And builders have great lawyers and they have thought of everything. I had a client, he purchased through a corporation and he couldn't close. So he comes to me, he's like, hey, entered into this agreement without getting it reviewed, obviously, and is now unable to close. And he was like to me, but I'm purchasing through a corporation. I reviewed that. It was like a 50-page document. I reviewed it, and there's a clause that says, if you're purchasing through a corporation, all directors are held personally liable.
Wow.
And so like, that's what I mean. Like, it's so one-sided. Because in a resale, if you did that, you'd be perfectly fine. But it's very one-sided. Get it reviewed, understand the clauses, cap your fees. It's something that a lot of people are learning you can do, is capping your fees. So you have builders, in a regular transaction, you have, purchase price minus deposit, a little bit of an adjustment for property taxes or condo fees, whatever. But generally, like, the number that you need. In new builds, could be like the furthest from the truth. Your purchase price may be one number, and the money that you need on closing can be significantly higher.
They got like development charges, like
they charge you for
levies,
everything.
Like, they got tons of stuff.
They charge you Terry on warranty, this and that. So what we always tell clients, especially when reviewing agreements, is I'm not saying like they have to charge them, because those costs are also like costs that they have, but just try to cap them, because then at least you also know what you're getting yourself into. Because if listen, all these fees capped at, even in the number's $50,000, okay, on closing, I'm going to need $50,000 more than I thought I needed. But what happens is you have, you don't cap these fees, and then all of a sudden on closing, you're like $150,000 short, because you're doing math based on one number and the builder's doing math based on another number. So definitely get your agreements reviewed. Your lawyer will suggest the caps themselves.
Because your $500,000 condo can turn into a $650 condo really quickly, and you're thinking quickly. You're at 500, but it's really $100,000 or whatever in closing if you don't cap it.
Even like assignment fees, amendments to add, because your mortgage qualification, your mortgage broker, suggests you add your sister or your spouse or whatever. I've seen builders charge like a $50,000 amendment to add a purchaser, which you needed to add them because you are already short money. So things like that, like if you can get them reviewed. I've had clients come that they didn't know that they couldn't list a property on MLS.
Yeah.
And they're getting a default notice from their builder being like, hey, clause X says you're not allowed to list on MLS.
Yeah.
You've listed on MLS. You're in breach of the agreement now. So yeah, definitely get builder contracts reviewed.
Yeah, that's crazy. I think we went off on like getting a lawyer review, but it's important. But it's important at the end of the day. But yeah, I think I appreciate you coming out and sharing your
Always a
knowledge
good
with
time.
us.
Thank
and
you.
Probably avoid some phone calls from me. and what we're going to do is we're going to put your contact information on our post so then they can contact you directly if they have any questions beyond this.
Perfect.
Guys, that kind of wraps it up for if you are a pre-con buyer and are going to be defaulting or you think you don't have an option. From what we've learned over here is that take action proactively before you get to a point and just don't ignore it because it's not going to go away. And the best thing that you could do is retain a lawyer. Call around, talk to some lawyers, figure out who you're comfortable with. Hopefully it's Gathya, but figure out who you're comfortable with and then get a lawyer on your side. Because even if, like what Gathya mentioned, like if they send you a small amendment, you don't really understand it, and running it through ChatGPT honestly is not your best option. I would actually get a real lawyer to review the agreement for you and be proactive about it and know where you're going to land. And if you start, I think 6 months or a year in advance, if you already know this is going to be your scenario, I think at least you will have more options. Because if you get to that finish line over there, I think your options pretty much shrink at that point, right?
Yep.
Yeah. Awesome. All right, guys. Hope you guys enjoyed this. Until next time, remember one thing, get Cabani, get sold.
Sell it, sell it, sell it, sell it, sold. Sell it, sell it, sell it, sell it, sold. Sell it, sell it, sell it, sell it, sold. Sell it, sell it, sell it, sell it, sold.